first matter to come before the court this morning is State of Ohio versus Jeffrey R. Pinnick. Both sides usually have 15 minutes to present oral argument. The state has waived, so you will have 15 minutes to present oral argument. Please don't use the names of any victims or minors as we are recording this oral argument. We posted on the court's YouTube channel. I would ordinarily ask if you want to reserve any time to rebut yourself. I don't think you need it. I'm keeping the clock, but you can also reference it on the law. The judges have read your briefs, and we are ready to proceed when you are.
Good morning. May it please the court, I'm Attorney Brad Harp. I'm appearing this morning on behalf of the appellant, Jeffrey Pinnick. I'm asking the court to consider, in this case, a legal issue with regard to the enhancement of penalties for an OVI offense. Specifically, what I'm asking the court to consider is finding that when a prior OVI is on appeal, that offense cannot be used to enhance a subsequent offense. That is what happened in this case. The reason why would be because the appeal could change things. Things could change. Now, in my research, I unfortunately did not find a lot of case law on point. I know that the state had decided to an unreported case from the 10th District from 1984, Pinnick versus State Medical Board. My review of that case and some of the cases that have cited Pinnick are, that's sort of a different matter. If you're going to suspend a medical license, that goes more to the fitness of a physician to practice as opposed to enhancing a penalty for an OVI. So, to me, in my mind, I find that distinguishable.
I thought the state cited for the rationale that once a case is, once a conviction occurs, what's being stayed is not the conviction but the execution of the sentence, generally speaking. So I get your idea those are completely different matters, but as far as that rationale that a stay of a criminal conviction for appeal is not of the conviction but of the sentence execution, what would you say about that part of the Pinnick case?
Well, I think that's one of the interesting parts of this case because the OVI statute for penalties refers to a conviction. There is a conviction that has been entered. Maybe the sentence is stayed, execution of sentence is stayed. But because the appeal is pending, things can change. What if an appellate court reverses the trial court? What if something happens?
From the fact of this case, we know that the appeal had been completed prior to sentencing. Is that, am I correctly reading the record? The appeal of Mr. Pinnick's, I'll call it the second OVI as opposed to the third, we know in this particular case that appeal had been denied at that point.
Yes, that is correct. September of 2022 was when the ruling from the first case was issued, and the sentencing hearing was in November of 2022 on this case. The distinction that I would draw is that it goes back to the time of the offense. I'm asking the court to consider that because the offense occurred in the instant case in July of 2022, prior to the final ruling on the appellate case from the year previous, that it's the time of the offense that should be used for the enhancement purposes, whether it's a second intent or a third intent.
In this case, a specific order as to that second offense, and the order that stayed that matter, did it stay the execution, did it stay the conviction, was it clear as to what the order was doing?
I'm not exactly sure, but I would assume that it stayed the execution of sentence.
Is that in the record before us in some capacity in this case, do you know?
I'm not sure about, so you're asking, is,
Because that's a separate case in this case.
yes,
So this case is over here. I assume the order went in that second case and not this case. Is that stay of case number 2 get in our record in case number 3?
I know I did file something to supplement the record, which the court did rule on. My reading, my take of what the court had decided with regard to supplementing the record, I know that the court said, well, we'll supplement it with the transcripts, I understand that. But my take on that order was that the court had that information from that prior case. So that's my understanding.
Would that being the case, would you think that this court could take judicial notice of whatever that order was in case, I'll call it in case number, that second OBI, we take judicial notice of whatever that stay order happened to say?
Yes. I would like to mention something that is in the record in terms of a sentencing memo that was filed in this case in the trial court. And I think that the reason I bring that up is because even in the trial court, cases are being handled differently in terms of what's considered an enhancement and what isn't. So I think it's a good issue. I think it's an issue that the court should consider. I think it's an important issue. And I'm asking the court to consider that while that prior case is pending appeal, that conviction, even if it comes out prior to the sentencing, that should not be used as an enhancement for a subsequent case. And I'm asking the court to consider reversing the judgment of the trial court and sending this back down for sentencing as a second offense in 10 years.
One more question for me. It seems to me that I recall from the briefs that was said that before the trial court judge, you folks argued State versus Wood is a case that was relevant. Now you're saying there isn't any case law that's relevant. So are you telling us that State versus Wood isn't particularly relevant to these facts at this point?
What I meant by the State versus Wood and the relevant case law, I took it as more, what I was trying to say is that's more at the trial court level.
Okay.
So that's different, obviously, not binding on this court, but just more of the point that this issue, I think, does need clarified, but I think it's a good issue. I think it's something that the court should take a look at.
In some capacity, State versus Wood consider the question of how to deal with the case that's on appeal as to how that would affect how that would work for enhancing the sentence, or was State versus Wood something different than only type of the trial court?
The State versus Wood appellate case was just on a motion to suppress. But at the trial court level, there was a subsequent OVI, and Mr. Wood did appear in the trial court and entered a plea, and the plea was treated as a first, it wasn't enhanced, I believe it was treated as a first in 10 when Mr. Wood appeared on that subsequent OVI. So my understanding is the State versus Wood at the appellate level was on motion to suppress, and that got sent back down to the trial court to consider.
So if I understand you, then perhaps it was offered at the trial court level, say trial court in the State versus Wood case way back when, this is what they did when they had the same problems at trial court level. They handled it by not using the first case to enhance the second because it was on appeal.
Yes.
But the actual appellate case of State versus Wood didn't deal with that issue, it just dealt with motion to suppress.
Yes.
Okay, very good, I understand, thank you.
Counsel, I just have one question, and that is in regard to, I would ask this of the state, but unfortunately they're not here, so I'll ask you, maybe you can enlighten me. If the appeal, I know this is hypothetical, but if the appeal had been reversed and the conviction vacated, would there be a remedy for your client? Because that's what you're most concerned about, right?
Yes. My take is, what I think would have happened, I think the trial court would have taken that into consideration and would have recognized that there had been a change. So, in that situation, yes, that would be beneficial to my client.
I just wondered if he had a remedy, that's all I mean.
Yes.
Okay, thank you.
I did want to say a little bit about what standard this court's going to use. I think, I know when I briefed this, I was looking at more of an abuse of discretion, but given the context of the case, I'm asking the court to consider that this should be reviewed de novo as a legal issue on how this enhancement should be handled and how trial court should look at this, to give perhaps the trial court some guidance on what they should do if this issue should come up in the future. So as I said, I'm asking the court to consider sending this back down to the trial court for the reasons I've given. That's what I'm thinking, Your Honors.
Thank you. Thank you for the presentation today. The court will take the matter under advisement. We will issue a written decision which will be mailed by the clerk of courts to all parties to this appeal on the day it's issued. Also, you can check the Ohio Supreme Court website because our decisions are posted on the website as well. Thank you.